In this class, we'll discuss question number 7, that is define hypothecation and distinguish it from pledge, and relating to that we'll discuss the decision of Andhra Pradesh High Court regarding State Bank of India versus S.B.Shah in 1995. So, hypothecation is not a statutory creation, but it is in usage in mercantile field times immemorial. The hypothecation is neither governed by any statute nor there is any law governing the same directly or indirectly. Therefore, courts have to consider hypothecation cases purely on general conditions of the contract as prescribed terms of hypothecation agreement. Hypothecation is understood in mercantile world as a creation of charge on movables in favor of hypothecated by hypothecator, where possession of goods will remain with the hypothecator. Thus, the hypothecator can be in possession of goods hypothecated and enjoy the same without causing any damage to the rights of the hypothecator. Where there is a mere change in hypothecation agreement, the hypothecator has to approach the court and seek intervention of the court for obtaining money decree and for bringing the hypothecated goods for sale through the court. When there is any specific clause in the hypothecation agreement empowering the hypothecator to take possession of the goods and sell the same in the event of default in payment as per the said terms, the hypothecator can proceed ahead without intervention of the court. Intervention of the court is not necessary and compulsory for enjoyment of a right, and the intervention of court arises only when there is an infringement of right, and when there is no infringement, there is no loss and no suit. In the hypothecation agreement, the rights of hypothecator are governed by the terms of agreement, where the agreement provides for making of possession of the goods hypothecated. The hypothecator can take possession of the said goods without intervention of the court, where the goods are hypothecated only by creating a charge. Then the hypothecator has to take action to enforce the said charge according to law. Therefore, it cannot be said that the hypothecator has to approach the court even though the deed provides for taking of possession in case of default of the hypothecator. If there is any violation of the terms of the deed, it will not however, bar the hypothecator to approach the court and seek proper relief. And regarding the very distinction between hypothecation and pledge, we will discuss the relevant decision of Andhra Pradesh High Court in 1995 in the leading case State Bank of India versus S.B.Shah. And the very distinction is that in case of hypothecation, the hypothecatee can be in possession of the goods hypothecated and enjoy the same without causing any damage to the rights of the hypothecatee, whereas in the case of pledge, the possession of movable will be transferred to the pony and he will be in possession and the pawnee will not be able to enjoy the same as the possession has already been parted with and it was decided by their learned lordship by the Andhra Pradesh High Court in the leading case State Bank of India versus S.B.Shah. And our next question would be question number 8. Enumerate and explain the rights of pony. And regarding that, we will discuss the first one, right of retainer as provided under section 173 and 174, and the second right of the pony relating right as to extraordinary expenses incurred as provided under section 175, and relation to that will discuss a leading case Bank of Bihar versus State of Bihar in 1971 as decided by our apex court, the Supreme Court. And regarding the third right of the pony, right of pony where pawner makes default as provided under section 176 of the Indian Contract Act, and in relation to that we will discuss the very important leading cases in relation to section 176, that is the State Bank of Hyderabad versus Susila and others in 1980 by the Andhra Pradesh High Court, and the second important leading case, that is Rehmat Ali Patte Ullah versus Lalan Prasad in 1962. The judgment was delivered by the Allahabad High Court. And the fourth right, that is of the pony, and that is the right due to voidable contract, and as the very right is explained under section 178A, and that will discuss in our next upcoming video question number 8 and question number